Greetings everyone. This is Ayushi Singh, Executive Member of Legal Vidya. I welcome you all in the fourth class of AIB crash course organized by Legal Vidya. So without further ado, let's warmly welcome our esteemed speaker, Advocate Nivedita Kondinya ma'am to the virtual stage. Over to you ma'am.
Thank you, Ayushi. Good evening, everyone. So, should I begin the class? Okay. So, yesterday we were doing family law, and we could only complete the Hindu law portion. And then I had just started discussing Muslim law. So, we will start from there itself. We will discuss Muslim law today, and then we will move forward to discuss the Indian Contract Act of 1872. Uh, Let me present my screen. I hope you have read this document. It was shared to you yesterday itself, and we will be doing Muslim law from this document itself. It is a document prepared by the Renensa Law College, and it is suitable for you for the purpose of AIB because it has a number of flowcharts, etc., and tables. So you will have whatever things you have to remember about it is very easily accessible from this document. So let us begin with the topic of marriage today. We have done the schools of Muslim law and the sources. So we will be doing it very quick because there are a lot of things to remember in this, but and there are a lot of concepts also. But since we have paucity of time as well. There are a few important topics which are recurring from Muslim law again and again every year in AIB. So we will be touching upon those topics only, and for your purpose also that will be sufficient for examination. So let's talk about marriage in Muslim law. So as I told you yesterday, in Hindu law marriage is a sacrament, or it is a sacrament. It is considered as something sacred. It is a sanskar which is part of the solar sanskars which a Hindu human by birth has to is gets has to follow it. But on the contrary, in Muslim law, marriage is a civil contract. It is between a man and a woman of who are Muslim, and they are lawfully eligible to be wife and husband of each other. And their objective is to lead a joint life and to procreate. Right now, what are the requirements of a valid Muslim marriage? It is offer and acceptance. It is the presence of witness, the capacity of the parties who are getting married, the free consent, and there should not be any legal disability to marry. So, since it is a contract, so all the essentials of contract will also be applicable here, right? So, when a contract of marriage is to be entered upon, then all these requirements have to be fulfilled. So, there has to be an offer from either spouse. So usually, when you see Muslim marriages, it is conducted. There is a kaji, and he asked the wife that from the groom side, there is provision of dower. So for this dower, are you ready to marry this person? And she gives her consent. So in this way, offer and acceptance is completed. Then there are minimum witnesses present there, so at least two male witnesses, or if female, then it has to be four females. And if there is one male, then there has to be two females. So usually two females minimum requirement is there for witnesses. If there is one man, then there has to be two other women, so there will be three. And if there are only women witnesses, then they have to be four. So basically, um the capacity of one male is equal to two women as per this theory. So this will be the this scheme will be followed at the time of choosing witnesses. Now the third one is the capacity of party. So party has to be the parties of the marriage has to be of a certain age. So basically, in Muslim law, since there is child marriage restraint act now, but then there are always disputes as to if a girl who has attained the age of puberty could marry, or will child marriage act will apply, and there is a dispute going on, and there are a number of cases on that also. But for the purpose of personal Muslim law, the capacity to marry for a girl is that she has attained the age of puberty. Okay. Then free consent is obtained. The wife, the girl who is consenting to marriage should be free of from any type of coercion, undue influence, uh, or fraud or anything. All the essentials which are there in the contract law will also be applicable here too. And then there should not be any legal disability to marry. So if there is anything which prohibits certain acts which is done by some person, and if it is done by that person, and the law expressly says that this person should not be married, then they should not be eligible to enter into the contract of marriage. So say for example, in this case, four marriages are allowed, right? So if there is a certain man who is trying to enter into fifth marriage, so here the legal disability will act upon, and then he will not be allowed to enter into a contract with a fifth wife, right? A fifth girl to be to make his fifth wife. Okay. So this is how a legal disability will bar him from entering into the contract of marriage. Now, this offer and acceptance and everything is discussed here, but we will not be getting into detail, because of offer, acceptance, etc. We will all be discussing in the contract law also. And I have already told you the presence of witness essential. Coming on to the next topic. So basically, in the topic of legal disability, you could see a number of disabilities could be there. So for these things, absolute prohibition will be applicable. So if there is any prohibited degree of relationship between the girl and the boy, then also the disability will act upon. It will be absolutely prohibited to marry if the girl and boy are within the prohibited relationship. If they are doing polyandry, polyandry means a woman having several husbands. So in Muslim law, a man could marry four wives, but women could not marry more than could not marry more than one husband, right? Now degree of prohibited degrees will also be there as per consanguinity, affinity, and fostera. So basically, fostera, affinity is sorry, consanguinity is for blood relations. Affinity is there if say suppose there is any prohibited degree from the side of mother, and then if they have fostered, right? So say suppose there is some women, and who has raised the child, or she has feeded that particular child, so then they will be considered as they will be under the prohibited degree of a relationship, and that subsequent girl and boy could not marry. Okay. And then coming on to the relative prohibition. So in these situations, the prohibited degree of relationship and polyandry, absolute prohibition is there. They cannot enter into the contract of marriage. But then there are certain other prohibitions also where they could also be waived if something if the circumstances could change. So say for example, unlawful conjunction, marrying a fifth wife, absence of proper witness, difference of religion, and marriage during iddat. So, so we had taken this example of marrying a fifth wife. So suppose if someone wants to marry a fifth wife, but it is prohibited by the law. But again, if he divorces his one of the wife, then he could marry the other wife. So it is a relative prohibition. It could be done away if the condition could be changed. Okay. say difference of religion. So if there is someone who is not Muslim, so they could either convert, right? And if he or she gets converted, then the marriage could take place, which will be a regular marriage under the Muslim law. So in this way, these relative prohibitions could be done away. Okay, moving forward, these things have been explained here also. So I am just doing away with it in very short. I'm just telling you the concept. You can always read it, but for the sake of time, we have to. I have to move away with this. Now, coming on to option of puberty. So, as I told you, the minimum age which is required for a girl to be able to marry is the age of puberty. So, this is the concept of khair ul bulk, which is also called as option of puberty in Muslim law, which means traditionally, see, in the Muslim law there was no age of marriage, right? However, uh, certain through all the juristic discussions and from all the sources of the Muslim law, it was agreed that okay, if a woman reaches the age of puberty, that means she is able. If a girl reaches puberty and she is able to procreate, because the object of marriage in Muslim law is to procreate. Okay, so if she is able to procreate, she is ready for marriage. This is the concept. So, option of puberty means when a minor girl has contracted a marriage, she can, after attaining the age of majority, she can repudiate the marriage. Okay. However, there is this exception to it. If a minor girl has contracted a marriage and she was entered into marriage by her father or grandfather, then that contract of marriage is valid and binding, and it cannot be annulled by option of puberty. So a minor who has been sent into marriage by her father or grandfather could not repudiate, could not annul her marriage even after attaining the age of majority. Okay, so this is the option of puberty. Coming on to Dissolution of Muslim Marriage Act of 1939, it has considerably modified the law of the option of puberty. And prior to the act, the concept which I told you just right now, that if she has been sent into marriage by father or grandfather, she has no right to repudiate such marriage on majority. But after the enactment of the Dissolution of Muslim Marriage Act of 1939, a girl could repudiate her marriage if she attains the age of majority, right? And or she can obtain a decree of divorce if she does not want to continue the relationship which she entered into while she was minor, and she was forced to enter into by his parents or grandfather or any guardian. Okay, but the most important thing here is the marriage should not have been consummated. Okay, so it should not be consummated. That means there should not be any physical relation between the husband and wife till the time of repudiation. So if she repudiates the marriage and it is not consummated, then she can obtain a decree of divorce. Let us come to the topic of classification of marriages. So there are three types of marriages in Muslim law: the Sahih marriage, the Batil marriage, and the Fasid marriage. So basically, Sahih marriage is the regular marriage, which is a valid marriage, which is entered into for fulfilling all the conditions required. Then there is this Fasid marriage, which is also called as irregular marriage, where there are certain conditions which are not fulfilled, and it is essential to the Muslim law, but it is also not void. Marriage is there, but it is not a regular marriage as per the Muslim law. But yes, it is a marriage, and there will be some conditions which may be fulfilled, and then that irregular marriage could also become regular marriage. Okay, and then this is batil marriage. Batil means void marriage. So there could be a marriage contract which is batil. Now let us come to the conditions how and when they will differentiate. So, Sahi marriage is a marriage which is fully valid and it is fully effective. It after entering upon the contract of marriage, which is of Sahi nature, then all the rights and duties of husband and wife will be executed and it will be effective. So, wife will get the right into inheritance and other things, and her child will be legitimate, and they will get the property, etc., etc., of the father. So, all the rights and duties emanating from a marriage will be available to the couple. Okay. Coming on to the next type of marriage, which is of batil nature. Now, batil is something which is a void marriage. Just give me a moment. Sorry for the disruption. Okay. So, talking about batil marriage, it is a void marriage. Under such marriage, there are no rights, there are no obligations existing between the parties. Okay. And they will be considered as guilty of sin as per the Muslim law. Okay. And if sorry whatever if there is any sexual intercourse taken between the couple, and if there are any other any other condition which is applicable only after marriage, if it is done between them, then it will be valid, it will not be valid, and they will be called as guilty of zina as per the Muslim law. Okay. And after and that marriage will be declared void. Now, coming on to the next type of marriage. Okay, let's have an example of how a batil marriage will be entered into. So, say for example, a man could not enter into a marriage of prohibited a marriage with some other person who is with under the prohibited relationship. Okay. So, if say suppose a man marries a girl who has been fostered by his mother himself, so that marriage will be a batil marriage. So where the absolute restrictions were applicable. Okay. So we just discussed the absolute restrictions and the relative restrictions. So where the absolute restrictions are applicable, all the marriages which are conducted with violation of the absolute conditions, then that marriages will be batil marriages. Okay. Say, for example, the bar of polyandry. If a woman contracts a second marriage during the subsistence of her first marriage, then it will be a batil marriage. Okay. Coming on to the third type of marriage, which is an irregular marriage, which is a marriage which is contracted in contradiction of the relative restrictions, then it will be called as fasid marriage. So there is no marriage, but it could be regularized after fulfilling certain conditions. So, say, suppose a man marries a girl who is not a Muslim, who is a fire worshipper. Okay. And the Muslim law clearly lays down that a fire worshipper is not supposed to be a Muslim, and whoever marriages with a fire worshipper, then that marriage will not be called as regular marriage. So if that woman converts into Islam, then that marriage will be regularized. Okay. Let's come on to the incidents of a Muslim marriage. So marriage has its own specific incidents and effects. Basically, it gives rights and duties, and the rights and duties are of the husband also, and there are some rights and duties of wife also, which has to be fulfilled if a girl or boy enters into the contract of marriage. So basically, they have some mutual rights. That means the children who are born out of such wedlock will be legitimate children. The children will have the right to inheritance. Husband and wife mutually will have the right to inherit each other's property, and they will have this allowance to enter into a sexual intercourse. Coming on to the next right, the wife will have the right to maintenance. Okay. And husband is having the right where his wife could not marry to any other person, and he will also have right to marry three other women also under the Muslim law. Then there is this other type of marriage which is called muta marriage. It is not prevalent nowadays, but it is a concept of marriage which evolved during the in Arab itself. So when the time after Prophet Muhammad died, there were certain tussle for the power, and there were a lot of wars going on between. So under the Shia sect of Muslims, there is a kind of marriage which is called as muta, where the husbands who went to the war, their wives were left, right? So all those women who had no protectors, basically Muslims believe, as per the Muslim law, it is believed that a woman should have a protector. There has to be guardianship of a man in a woman's life, right? So either it should be his her husband, or either her father or grandfather or brother, anyone, right? So since there was scarcity of men due to war, so a man used to marry a man used sorry, this is the concept of polygamy. I am mixing. Sorry. So when man used to go on war, they since they used to have to live for a longer period of time there. So till that time they are in the war in a different place away from their families. So they were allowed in the Shia sect, not in the Sunni sect of Islam. In the Shia sect, they were allowed to marry some women there. So for marrying that woman, they only used to give some consideration, some money in consideration, and then they used to marry her, and they cohabit with her, and afterwards they return back, and there are no rights emanating from this that particular marriage. Okay, so there are no mutual rights of inheritance in the property of the man, which is created between the spouses by the marriage. However, the children who are born out of such wedlock were considered legitimate, and therefore they could inherit the property from their parents. Okay, so it is a kind of marriage which is somehow different from prostitution, because prostitution is a practice which is not not validated by the law, not validated by the Muslim law also. So to save men from prostitution, but to provide them a way, this kind of marriage was initiated. However, this kind of marriage is not in practice right now. Then there are certain other conditions also. Say for example, if marriage is not consummated, then wife is entitled only to half of the dower which was promised by the husband at the time of marriage. And it is if it is consummated, then she's owner of the to claim the full dower. On the also, since this is a muta marriage, it is for a particular period of time, and a term of marriage used to be fixed at the time of marriage. So on the expiry of the term of marriage, if the marriage has been consummated, the wife was required to go to iddat period. Okay, however, husband has no right to refuse procreation. Okay, and since it is a marriage for a fixed term, so once the term ends, the marriage itself comes to an end. Now coming on to the types of dower, which is very important for the from the perspective of your examination. Just remember the types of dower and their Arabic names. Okay, so basically what is dower? Dower is a amount which is promised at the time of marriage to the women. Okay, so from the husband side, amount is given to the women. Okay, and that is called as dower. And dower could be given at the time of marriage, or it could be promised and it could be recovered by the wife afterwards, or she can also claim it after the divorce if it has not been given her what was promised. Now there is no quantity of dower which is fixed. Coming on to the types of dower, So dower could be a prompt dower or it could be a deferred dower. The parties may agree between themselves when the dower shall be paid. If it is paid immediately, then it is a prompt dower. And if it is to be paid after marriage, then it will be called as deferred dower. Let's come to a very important topic, the divorce under the Muslim law. Okay. So, since Muslim marriage is a contract, it was a contract initially also. So, the concept of divorce was existing since the Islamic law has started. So, here are the types of divorce or the modes of divorce as to how divorce could be obtained or can be secured in a Muslim marriage. So it could be now considered under two heads, extrajudicial divorce and then judicial divorce. Judicial divorce is basically what is as per the law which was passed in 1939, that is the codified law. And extrajudicial divorce is the kind of divorce which is practiced by the practice under the personal Muslim law. Okay. So under extrajudicial divorce, there are three types: by husband, by wife, and by mutual consent. So by husband, there are three types of divorce. It could be done by talaq, or it could be ila, or it could be zeher. By wife, it could be talaq e tafweez it is, and then lian, and then under dissolution of Muslim Marriage Act. Then there is this mutual divorce by mutual consent, that is khula and mubarat. Remember these words very clearly. Okay. Then talaq could be done by either by the way of talaq a sunnat and then talaq e biddat. Now, talaq e biddat is a form of talaq which is now criminalized, right? So, talaq e biddat, in normal words, it is triple talaq, which was popular, very popular in India. It is practiced by the Hanafi sect of Sunni Muslims, and in India, the majority of Muslim population is of Hanafi sect of Sunni Muslims. So talaq-e-biddat was very much popular here, and a husband used to utter three times talaq, 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 and talaq would happen. So to protect the interest of wives, uh, talaq-e-biddat was criminalized now. So in your 2018 judgment, I would ask you the judgment also, because it was very popular. It was a landmark judgment. So I would like you to tell me which judgment it was. There, talaq was criminalized. Talaq biddat was criminalized, basically. Does anyone remember it? The name of the judgment? No one. Okay, let me give you a homework. So in tomorrow's class, just be prepared with five landmark judgments related to say criminalization or to for the protection of rights of basically it is considered a part of human rights. Okay. So in some judgment, there is a judgment which protects the rights of transgenders. There is a judgment which decriminalizes unnatural sex. Basically, it decriminalized section 377 of IPC. Then there is a judgment which declared talaq e biddat as unconstitutional. Then there is one judgment which declared adultery as which decriminalized adultery. So I want you all to be to search these judgments and come up with the answers tomorrow. Okay. And these are very landmark judgments since 2015 to 2021. Okay. So now talaq-e-biddat in India is unconstitutional. It should not be practiced. And whoever practices talaq-e-biddat would be imprisoned, and he will face imprisonment and fine also. Now coming on to talaq-e-sunnat, it could be also done in two ways: talaq-e-ihsan and talaq-e-hasan. Now here you could find all basically who can give talaq. So at the time of talaq also you have to be in capacity to give the talaq. So every Muslim husband who is of sound mind and who has attained the age of puberty can pronounce talaq. Okay. uh, there should be free consent of the husband. Also there should be the required formalities has to be fulfilled, and express words has to be there. Coming on to divorce by mutual agreement, there are two forms of divorce by mutual consent, but in either of them the wife has to part with her dower or to part of some of their property. So basically when a wife has been given a chance to divorce or a right to divorce, then she has to somehow uh, uh, compromise with her rights as to divorce or to rights of inheritance in the property. Okay. So there are two types. This is khulla and mubarak. So in khulla, it means to take off, and it is it in the law, khulla means a divorce where an agreement is between the spouses so that they could dissolve their intimate relation, their union, and they really the wife does away with the dower. Okay. In Mubarak, both the husband and wife are happy to get rid of each other. And however, there is difference between Sunni and Shia law regarding Mubarak. So in Sunnis, when the parties to marriage into Mubarak, all the mutual rights and obligations comes to an end ipso facto. So just as and when they enter into Mubarak, all their mutual rights and obligation would be ending that at the same moment. However, in case of Shia law, it is different. It requires that both the parties should bona fide find the marital relationship to be where they could not sustain, and only then they could enter into Mubarak. So there have to be a valid reason as per the Shia law to enter into Mubarak. Now, wife can divorce also. So this is talaq e tafweez and then liyan, and by dissolution of Muslim Marriage Act. Talaq e tafweez means it is a delegated divorce and it is recognized both in Shia and Sunni law. A Muslim husband is free to delegate his power to pronounce divorce his wife or to any other person. So basically, it is on the husband itself that if a husband delegates his power to pronounce the divorce to his wife, then a wife can also proclaim divorce, and this is called as talaq e tafweez or delegated divorce. Okay. In case of liyan, if the husband alleges some false charges of unchastity, basically he questions the chastity of women, or if he alleges that she is into adultery, right, against his wife, and the wife find it as character assassination of herself, then she has right to ask for divorce on these grounds, and this is called as liyan. So basically Muslim law provides two forms of divorce to the women, where under number one, in talaq e tafweez, if a husband delegates his power to his wife, then wife can claim for divorce. And if a husband levels false charges of unchastity or adultery, or does character assassination of the wife, then she could ask for divorce, and that will be called as liyan. And then there is Muslim Marriage Act, dissolution of Muslim Marriage Act, where women can also seek divorce. So, for the purpose of AIB, I have analyzed the paper of at least 6 to 7 years, and I have found that from Muslim law, topics which are very recurrent or there are questions are only divorce, marriage, schools, and sources of Muslim law. Okay. So we are not going into other topics also because we don't have much time left, and there are a lot of course to be done. But then read section 125 of CRPC and cases related to it regarding the maintenance of Muslim wife. Okay. Here, other than that, you could read the scheme of inheritance as to how property is inherited by a Muslim legal heir. Other than that, it is all from Muslim law because I have seen recurrent questions from only these topics which we have already discussed. So let's come to the topic of let's come to the Contract Act. Are there any questions from Muslim law? Whatever we have read today, do you have any questions? Before moving forward, I can answer those questions, and then we could proceed to the Indian Contract Act.
No, ma'am.
Okay, okay, fine. So let us discuss the Indian Contract Act. I have prepared this important topics and questions for Indian Contract Act here, once here all, and then we have some certain questions from the Contract Act. See, Contract Act is very important portion for AIB examination, and there are certain questions which are repeatedly asked in the AIB examination. So I have listed those questions here. We will discuss it after we have discussed the theoretical portions. And I have also mentioned the recurrent topics, the topics from where questions are being asked. So let's begin with what is contract. So I would request you all to at least have your bare acts when we are discussing. So yesterday, I had already told you that we will discuss the Contract Act. So I would suppose that you have the bare acts. Otherwise, I have also downloaded the act, but navigating it would cause some time also. But okay, let's do it. So starting with what is contract. So basically, coming on to the Indian Contract Act, its enactment date is here, 25th April of 1872. Whatever bare act you are reading, just be versed with its preamble and its enactment date also. Why? Because there are certain questions which have been asked from what was the enactment date of certain act, or what does the preamble of certain act says. So these could also frame your questions. So if you will be aware with it, you can do it at once, or then otherwise you have to navigate through your bare acts also, and that will consume your time. So let's begin the preamble. It says that whereas it is expedient to define and amend certain parts of the law relating to the contracts, then number one, it the extent is it extends to whole of India. So this question has also been asked in three of the 3 years question paper since 2014, and the question is, what is the extent or what is the jurisdiction of the Indian Contract Act? So it extends to whole of India now after the 2019 Jammu Kashmir Reorganization Act. Otherwise, before that, the status was that it extends to whole of India except Jammu and Kashmir. Now come to the very important part, which is interpretation clause. Okay. Now this is of very utmost importance because a number of questions could be from section 2 itself. So what does section 2 provide? Number one, it provides the definition of proposal. Okay. So it says that when a person signifies to another, okay, number one. Number two is his willingness to do or to abstain from doing anything. Number three, with a view to obtain the assent of that other person. And fourthly, uh, and the assent to what? To such act or abstinence, then he is said to make a proposal. So basically, we get the essentials of proposal from this clause. How? So a proposal will consist of person, okay? Then there will be communication of his willingness, okay? Willingness to do or to abstain from doing something. So three essentials are there. Then fourthly, and why he is communicating his willingness, so that with a view to obtain his consent. And why he is obtaining his consent, so that he could do such act or he could avoid to do such act what he is wanting. So basically he wants to convey to some other person that I want you to do something, are you agreeing to it or not? Okay. So in this way a proposal is being made. So essentials of proposal would be, there should be a person, there has to be communication of willingness, there has to be a view, there has to be an intention to communicate that willingness, so that that person could give his consent. Okay. So intention is to gain the consent of the other person to whom we are communicating our willingness. Are you getting my point, participants? Is
Yes,
it
ma'am.
clear? Okay. So this is how proposal is defined. So very straight questions are also being asked. For example, where proposal has been defined in the Indian Contract Act. So it is section 2A. Okay. Coming on to section 2B. It defines what is a promise. So what is a promise? When a person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So number one, a person was there who was communicating his willingness to do or to abstain from doing something, and he had this intention that the person to whom he is making such willingness, he is communicating his willingness, that person agrees to it, and then that person agrees to such proposal. Okay. And if that if when the person agrees to a proposal, then that becomes a promise. Okay. Coming on to the next definition, the person who is making the proposal is called promiser. The person who is accepting the proposal is called the promisee. Now, the definition of consideration. So, when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or to abstain from doing something, such act or abstinence or a promise is called a consideration for the promise. Just a second, just a second. Okay, so in this definition, you have to be very careful with the three expressions. Number one is has done or abstained from doing. Number two is does or abstains from doing. And lastly, it is promises to do or to abstain from doing. Okay. Now, why I have, is it not visible? My screen is visible to you all? Okay, okay, okay. Sorry, it is not visible what I am doing here. So sorry, I wanted to see you this, then I was sharing some other slide. Okay. So here section 2D is there. I have colored in three colors, three expressions, and I was going to tell you the difference between these. So section 2D defines consideration, but it has three different expressions which are of utmost importance given your examination. Okay. And what is that? When at the desire of the promiser, the promisee or any other person has done or abstained from doing, does or abstain from doing, or promises to do or to abstain from doing something, then such act or abstinence or promise is called as consideration for the promise. So, whatever promise two parties are entering into, if the other party, that is the promisee, agrees to do something, okay, after the proposal has been made to him, then that is called as the consideration for promise. They have to do something for that proposal, and that will be called as consideration. Now, there is a question which has been frequently asked, and it is, let me go to the question again. Just a second. So, the question was, the question was the consideration under Indian Contract Act may be, options were only past consideration, only present consideration, only future consideration, and the fourth was all of the above. So why I am telling you this repeatedly and I have colored it in three colors is because of this question only. So consideration could be of past, future and present nature. Okay. And how we have inferred that? Because from the expression which is in pink color, it signifies a past consideration. Someone has done something or he has abstained from doing something. Okay. So it is past. Or does or abstain from doing. It is signifying present status. And then promises to do or to abstain from doing, it signifies the future status. So consideration could be past or present or future. Okay. So whenever these questions come to your examination, before navigating to your barrack, before being panicking about where to find the answer, just remember that consideration could be made in present, it could be past, or it could be in future also. Okay. So that is consideration. Now, every promise and every set of promises which form consideration for each other is an agreement. So, section 2E defines agreement. Promises which forms the consideration or part of the consideration for each other are called reciprocal promises. Okay. So, what are reciprocal promises? Which forms the part of the consideration or which forms the consideration. Okay. Then section 2G defines a void agreement. An agreement which is not enforceable by law is called void agreement. And 2H defines a contract. So, a contract, what is a contract as per Indian Contract Act? It is an agreement enforceable by law. Okay. And now 2I defines voidable contract. It says that an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the others, is a voidable contract. So basically, there is a principle which says that whoever makes something can also make it come to an end. Okay. So the parties who are entering into any agreement, so they can also choose to make it not happen. So there is an agreement which is enforceable by law at the option of one or more parties, but at not the option of other parties, other person, then it is a voidable contract. So say suppose there is a agreement entered into between two parties. However, there is a person who was under undue influence. Okay. but they entered into the agreement, and the other person gave his consent due to undue influence afterwards. Now that agreement is not sorry, that agreement is not unlawful, it is enforceable by law, but the consent was not free consent, which is a very important aspect of a contract. It is an essential of a contract. So in such a situation, you will find under section 17 of the Indian Contract Act that if a consent is influenced by undue influence, then it is a voidable contract. So one party has this option to either enter into either perform the agreement or to not the perform or not perform. So this is what is being signified by the this clause. An agreement which is enforceable by law at the option of one or more of the parties. So if one party who was influenced by the undue influence can say yes, I want to make it enforceable, so it will be enforceable and it will be valid. And if he says I don't want to do it, then that contract will not be enforceable. So it is a voidable contract.
Ma'am, but how can this be same? Because if an agreement has been made due to undue influence, then it will be void only in the first place.
No, see, for that you have to go through the section. So section the provisions of the contract act talk about certain situations where the contract would be void ab initio. Okay, it has no standing in the eyes of law. But then there are certain situations where the act says that there is a contract, but it is voidable. It could be either enforced or it could not be enforced. And it will depend on the party who is suffering from that, where consent is not free. And those situations are listed, and they are undue influence, there is mistake, there is coercion. Okay, so we will go to that. And in those so the categories of the contract have been provided, their categories of the situation has been provided, and based on those situations they have been categorized as valid, void, or voidable. Okay, because at the end, even in the voidable contract, there was an agreement. Okay, there was this proposal, then proposal got accepted, acceptance was also conveyed, then it became a promise, and the promise had also certain consideration. So the essentials of contract have been fulfilled. Now the consent which was obtained was afterwards, it was found that it was not a free consent. Okay, but all the other essentials, all the essential conditions have already been fulfilled. So it is an agreement which is enforceable by law. Okay,
Okay, ma'am.
but the party, huh?
So in this scenario, we are talking only about the free consent, right? Like when
Yes,
suppose
yes, yes, yes.
there are other conditions of the contract, and only the free consent, the condition that it should be free consent. So that was disclosed in the end that it's not a free consent. So that's how it became voidable.
Yes, yes.
Okay, okay, ma'am.
Okay, so moving forward with next definition. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So see, there could be a contract which was enforceable at the beginning, but afterwards it became unenforceable. So, for example, we can have suppose there is a war going on between Ukraine and Russia. There is a war going on between Israel and Palestine. Okay, now both the countries says, as per their law, they had they would have permitted trade between two countries. But at the time when countries at the war, there would be trade restrictions. Okay, so there may be a contract between a company who is which is situated in Israel, and there could be a second company which is in Palestine. Okay, now these companies entered into a contract to perform certain certain thing. Now after the war was declared, as per their law, no contract, no performance of contract could be done, or no business would be done between both the countries when the war was declared. Okay, so before the war declaration of war, the contract was enforceable. Afterwards, after the declaration of war, it became impossible. It became unenforceable. It ceases to be enforceable by law. Are you getting my point?
Yes, ma'am.
Okay, so after that it will become void. So it was a valid agreement, it was a contract before, but afterwards it ceased to be enforceable by law and therefore it became void. Okay.
So, ma'am, it's a voidable contract, right?
No, it is not
Because
voidable contract. It was a valid contract and afterwards it became void. It is not voidable. There is no option between the parties.
okay, okay.
Coming on to the communication, acceptance, and revocation of proposals. So, Section 3 talks about the communication of proposals, acceptance of proposal, and revocation of proposals. They are they are done between the parties. Sorry, just a second. Yeah. So coming on to section 4, which is also of utmost importance. So section 2, section 4, section 7, these are some of the basic sections from where mostly questions are coming from these sections only, from the Contract Act. So let's talk about section 4. Also, one tip I would be giving you all, that go through all the illustrations of the Bear Act. Okay, so in contract or in transfer of property act, the Bear Act is of utmost importance. Why? Because apart from the landmark judgments, mostly questions are based on the illustrations from the sections. Okay, so go through all the illustrations. Sometimes they used to give you word problems, and those word problems are exactly the copy of illustrations, or sometimes they are the illustrations itself. Okay, so go through the illustrations very well. So coming on to section 4. Section 4 talks about when a communication would be complete. So number 1, a communication of an acceptance is complete as against the proposer when it is put in the course of transmission to him so as to be out of the power of the acceptor, and as against the acceptor when it comes to the knowledge of the proposer. To explain this, come to the illustration. Suppose A is a person who is making a proposal by way of letter, and he offers to sell his house to person B, and the consideration is certain price. Okay, so as per the law, if B agrees to pay the certain price, then he is accepting the proposal. Okay, now as against A, when A sends out the letter, then it is put into the course of transmission. So communication is completed from the side of A. Now when B will read that letter, okay, so B is the acceptor. So when it comes to the knowledge of the proposer, so B will read the letter, he will write his acceptance, and then he will post the letter of acceptance to the address of A. So when A will when B will post his letter and it will come in the knowledge of A, then it will be completed as against the acceptor. Okay, so A will then uh, know that it has been accepted. Whatever proposal he has made has been accepted. So then communication will be complete as against A. And for the as against B, let's do the other illustration also. B accepts A's proposal by a letter sent by post. Okay. So here A's communication has been done. The communication of acceptance is complete as against A when the letter is posted. So as I told you in the previous illustration also, then A send his letter proposing whatever he is proposing to sell his house at a certain price. Then his the communication against A has already been completed. Now when B will read that letter, he will communicate his acceptance, and when the letter of acceptance will be received by A and he will read it, then the communication will be complete as against him. Okay. Similarly, the communication of revocation is also done. So if certain person wants to revoke the proposal, then when he will send his revocation, it will be accepted by B. When he will send his revocation against his sorry, his communication is completed, and when the other person will receive his revocation and he will also tell him, then there the communication will be completed. Okay. So you have to be very much clear about this timeline as at what moment communication will be completed of proposal or of revocation. A proposal could be revoked at any time before the communication of its acceptance is complete as against the proposal, but not afterwards. So, if, say, in the previous example, we had A. So, if A proposes something and he posted the letter, he wants to convey his revocation also. So, revocation has to be done before it is the communication is being accepted. Okay. An acceptance may be revoked at any time before the communication of acceptance is completed as against the acceptor. So whatever timeline was provided in section 4, so before the timeline finishes, revocation could be done. Afterwards, it is not possible to revoke the contract. Afterwards, there is only one thing, which is after entering into the contract, parties may mutually agree to uh, uh, to frustrate the contract, or then there may be other ways to fulfill the contract. Okay. See, here also illustration has been provided. The same illustration is there. A proposes by letter sent by post to sell his house to B. B accepts the proposal by letter sent by the post. A may revoke his proposal at any time before or at the moment when B posts his letter of acceptance, but not afterwards. And B may revoke his acceptance at any time or or at the moment when the letter communicating it reaches A, but not afterwards. So, say they are sending a letter, but afterwards, after sending the letter to B, A has some other plans, and then A calls B and says that I have sent you a letter, but I don't want to enter into this contract. So I want to revoke my proposal. So that proposal will be revoked. Now B, after receiving letter of A in another case, he gives his acceptance, he posts his letter of acceptance, and afterwards he has some other plans, and he after change of the plans he calls A and says that okay, I have sent you the letter of acceptance, but I don't mean it, and I want to revoke my acceptance. So he could do so, but after letter has reached A and A has read all everything in it, B cannot revoke it. Okay. Section 7 says that the acceptance must be absolute. There should be no conditional acceptance. It has to be unqualified. It has to be absolute. Okay. So if someone suppose A offers something to B, and B says that okay, I will accept your offer, but I have this offer to you also. Or either I will accept your offer, but then on certain condition. So it will not be a valid acceptance. Okay. So a proposal to be converted into promise, the acceptance must be absolute and it has to be unqualified. Now let's come to Section 10, which talks about what agreements are contracts. So section 10 says that all agreements are contracts if they are made by or by the free consent of the parties who are competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. So basically, the essentials of contract have been mentioned in section 10. And what are these essential? Number one is free consent of the parties. Number two is parties should be competent to contract for a lawful consideration with a lawful object, and it should not expressly be declared to be void. Okay. So if there is, say, there is a section which says that any agreement which is in restraint of marriage is void. So it is expressly declaring certain agreement to be void. So if someone enters into an agreement uh, to not make happen someone's marriage, then that agreement will be not a contract because it is a void agreement. So if certain agreements are expressly declared to be void by the act or any other law, then it will not be called as contract. For a contract, an agreement has to be made with free consent of the parties. It has to be, the parties has to be competent to the contract. That means they have to be sound mind, they have to attain majority. Okay. And then there should be a lawful consideration with a lawful object to be conducted. Then only any agreement would be called as contract, and only then an agreement would be enforceable by law. Also, nothing herein contained shall affect any law in force in India, and not hereby expressly repealed, by which any contract is required to be made in writing or in presence of witness, or any law relating to the registration of document. Okay. So what this clause meant to say is that if there is any law which is in force in India which says that there has to be the contract has to be made in writing and in presence of witness or anything relating to registration of document, then whatever law which is saying this, that law would be applicable and it will not be affected by the provision of section 10. Now section 11 talks about who are competent to contract. So every person is every person is competent to contract who is of the age of majority according to the law of the land, and who is of sound mind and is not disqualified from contracting by any law or to which he is subject. So there should not be any legal disqualification. He has to be of sound mind and he has to be a major. Then section 12 talks about what is a sound mind. So sound mind means he is capable of understanding it and forming a rational judgment as to effect upon his interest. Because contract gives rise to certain rights and it also gives rise to certain obligations. So you have to be capable to understand the gravity of what you are going to do, because then you have to fulfill certain obligations also. You will enjoy the rights, but at the same time you will have to follow certain obligation, and if you are not following the obligation, then someone other's right would be affected. That is why you have to be capable of understanding it and forming a rational judgment. Then there is a person who is usually of unsound mind but occasionally of sound mind. He can make a contract when he is of sound mind. So at the time of making of the contract, it is very important you have to be of sound mind. Either you are usually unsound mind, or either you are usually of sound mind but occasionally you are unsound mind. But at the time of making of the contract, you have to be sound mind. Then section 13 lays down very important provision which says that consent only means that two persons are agreeing on same thing in the same sense. Okay. So it is also very important as to what the other party is consenting has to be something what the other party has proposed. For example, A is proposing to sell a house to B, and B agrees to purchase the house at certain consideration. Now, the house which is in the subject, which is the subject matter of the contract, is not the same house to which they both are talking. So A is trying to sell, proposing to sell a house named B. Sorry, a house called, suppose the house called R. And C is consenting to purchase a house called S. So they are not agreeing upon same thing in the same sense. Are you getting my point? So section 13 says that consent has to be on the same thing in the same sense. Okay. Then free consent is also defined, and it is a consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. Okay. So read the provisions of section 15, 16, 17, 18, 20, 21, and 22. Because we are running short of time, we will not be doing that, but it is very clear in nature. So all these sections define what is coercion, what is undue influence, what is fraud, what is misrepresentation, and what is mistake. Let's hop to the topic of section 21. It is of utmost importance. Why? Because it talks about the effect of mistakes as to law. And there are questions which have been asked from this topic. So, section 21 provides that a contract is not voidable because it was caused by a mistake as to any law in force in India. But the other clause says that a mistake as to law not in force in India has the same effect as a mistake of fact. Okay. So, if there is any contract where it is claimed that it is caused, the consent was given because mistake of law was there, so it is not voidable at the option of the party who is claiming mistake of law, because the general presumption of law in India is that everyone knows the law. Okay. So any law which is in force in India, mistake as to that law will not be considered here, and therefore the contract will not be voidable. It will be considered as free consent and the contract would be valid. However, if there is mistake of law not in India but from other law, law from the other land, then it will be considered as mistake of fact, because no one could be supposed to know all the laws which are enforceable in all the other territories. But at the same time, you are expected to know the law of your land. Okay. Now, what is mistake of law is providing? So, as per section 19, sorry, not 19, uh, there is mistake. Okay, basically section 20 says that where both the parties are under mistake as to matter of certain fact, then that agreement is void. Okay. If one of the party is under mistake of fact, then it will be voidable. Okay. So either party could be under mistake of fact, and mistake of fact would be making the contract as voidable. However, if both the parties are under mistake of fact, then that contract would be void, because under mistake of fact, both the parties are entering into a contract where they are not agreeing to the same thing on the same sense. Okay. So that contract would be, sorry, that agreement would be void. But if they are if the party is consenting but it is suffering from mistake of law, then which is in force in India, then it will not be voidable, it will be a valid contract. Go through the illustrations very carefully, it is very important for your examination, because you may get the illustration itself as the question. Okay. Okay, section 23 talks about what consideration and objects are lawful and what is not. So section 10 has provided that the consideration has to be lawful, and it has the object should also be lawful. So section 23 talks about what is lawful, what considerations are lawful. So consideration or the object of an agreement is lawful unless it is forbidden by law. So basically it should not be forbidden by law. It should not be of such a nature that if it is permitted it would defeat the provisions of any law. It should not be fraudulent. It should not involve any injury to the person or the property of another, and it should not be immoral or opposed to public policy. So there are these 7 types where considerations or object could be unlawful. Otherwise, consideration or objects could be called as lawful. Every agreement which the object or consideration is unlawful is void. Okay, so it will be void ab initio. Oh, so let's hop back to our document. So we are done with what is contract, what are essentials of contract, communication, acceptance and revocation of proposal, consideration, types of contract. Okay, let's go to wagering agreements. Sections 24 onwards talk about void agreements. So what agreements are void? Section 24 talks about the agreement where any single part of the consideration or one or more objects of the consideration or any part or several parts of the consideration or the object is unlawful, then the agreement will be void. Okay. So if there is a consideration but a part of the consideration is unlawful, then whole agreement will be void. It will not be a contract. Okay. Then 25 says that agreement which is without consideration is void. Okay. However, there is certain exception which says that unless it is an writing and registered, or it is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law, and it is in writing and registered, then only an agreement without consideration will not be void. Okay. Otherwise, all the agreements which are without consideration are void agreements. Then 26 talks about the agreements in restraint of marriage. As I told you before, these are void agreements. 27 says that agreement which are in restraint of trade, they are void. 28 says that the agreements which are in restraint of legal proceedings, they are also void. Then section 29 says that agreements which are uncertain in nature will be void. So suppose there is an agreement between two parties, but the meaning of that agreement is not certain, or it is not capable of being made certain, then it is a void agreement. So we can move to the illustrations to understand it better. So A agrees to sell to B 100 tons of oil of a specific description known as an article of commerce. There is no uncertainty here to make it the agreement void, because everything is very clear. 100 ton of oil. So basically what will be the amount of a specific description? So the description of the oil, what will be the type of oil, everything has been provided, and it is also known as article of commerce as per the law of the land. So there is no uncertainty here which will make the agreement void. However, let's go to the first illustration. A agrees to sell to B 100 tons of oil. Now, which type of oil, what oil, from where it is incurred, who will be from where it will be transferring, nothing has been mentioned. No description has been provided. Only it is written that A wants to sell to B 100 tons of oil for this consideration. Now it is an uncertain agreement. There is no certainty as to what oil they are talking about. and therefore this agreement is void agreement. Okay. Then section 30 says that the agreements by way of wager are void. Wagering agreements are those agreements where uh, where any person who okay, where a person enters into an agreement where they are, say suppose they are into in the middle of any game, or they there is any uncertain event. Okay. So say suppose the person they are into gambling and they agree into something. So whatever agreement they are entering into relating to that gambling or any such game or any uncertain event, then that will be called as wagering agreement, and any agreement by way of wager is a void agreement. However, section 30 also provides for exception in favor of certain prizes of for horse racing. So this section will not deem to render unlawful an agreement related to horse racing. And here this section has also provided this exception has also provided the sum of money which is of value or amount of 500 rupees or upwards to be awarded to the winner or winners of any horse race. So basically this was the practice which was prevalent at the times of the Contract Act. It should be it should be removed from the act now, or it should be either it has to be regulated better, because there are a number of other games also now which are of the same nature. However, this needs an amendment, but at the moment we have to read this. So exception has been provided for wagering agreements which are not void, and that is for horse racing. Then section 31 to 34 talks about contingent contracts, and contingent contract means a contract which is a contract to do or not to do something for some event which is happening in future. Okay. So if some event will happen or not happen in future, based on the event, a contract is entered into. Suppose there are two persons who are entering into a contract of paying a certain consideration based on the event, and the event is, if there is a certain ship and if it will sink, person A will provide the other with certain amount of money. So the whole contract is dependent upon an event, and the event is the ship will sink or not. So if the ship will sink, then the contract would be enforceable. And the ship, if it not sink, then the contract would become impossible. Okay. So these were some very important topics for the purpose of AIB examination. There are other topics also which are important, but at the same time, they are not important for the purpose of your examination. However, you should read section 52 onwards also. Not 52, but 56. 56 is important. 56 talks about agreements to do impossible acts. Okay. So as per section 56, an agreement to do an impossible act in itself is void. It also has two categories: a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promiser could not prevent, unlawful. It becomes void when the act becomes impossible or unlawful. So basically, it wants to say that the agreement to do an act was made impossible because the act became impossible afterward the contract was made. So in this situation also, it will become void after the contract was made. And section 56 initially provides that any agreement which has been entered into to do a certain impossible act will be void ab initio, because at the initial stage itself the act was impossible. However, from the other clause, it is said, it is conveyed that certain acts could become impossible afterwards the contract has been made. So contract was not void ab initio, but it was since the act became impossible, the contract became void. For example, uh, as I said you, the declaration of war. So if there is a trade practice between two nations and they used to enter into contracts, so that will be a valid contract. Okay, they could enter into such agreement. However, if they enter into an agreement and afterwards the war is declared, so that agreement will not be a contract then, because the act will be impossible now. The trade has been prohibited after the declaration of war, so it will become void afterwards because act has become impossible. So with this, we are done with some important sections of Contract Act. Other than that, do read the act once again. The consequences of the breach of the contract has to be read. Contingent contracts chapter has to be read. Then read chapter 5 of the Contracts Act, which deals with the quasi contracts, and read all the illustrations. Very carefully read all the illustrations from all these chapters which we have discussed. Now let us discuss some questions which are recurring questions from Contract Act, and then we will end the session. Okay, so here I have also listed some important doctrines: doctrine of novation, privity of contract, doctrine of frustration, and quasi contracts. Just read it. It is written in very simple language. We are running short of time, so we are not going to deal it into detail. Let us discuss some. Okay, also I have mentioned these important cases which are recurrently asked in AIB examination. But these cases you will also find in your Bear Act also. It will not be available in the Bear Act without comment, but the Bear Act which you are having at the moment, you can read it. Carlil versus Carbolic Smoke Balls case deals with what? It deals with general offer. Then Bhagwan Das, Govardhan Das, Kedia's case deals with anyone? Can anyone tell me to which topic this case is related to?
Misrepresentation.
Bhagwan Das, Kedia's case.
Uh, Sorry, ma'am.
No, you may be right, but at least be confirm of what you are telling. Okay, it talks about offers, right? It is relating to communication and acceptance and revocation of offers. So basically, you will find case laws in your examination, generally from the topics of communication, acceptance, minus contract, and general offers. Okay. So I have listed. So Bhagwan Das, Govardhan Das, Kedia's case is relating to the acceptance of offer as to it will be said that the acceptance has been conveyed. So it is related to that. Coming on to the next case, Pharmaceutical Society of Great Britain versus Boot Cash Chemicals. It is related to also related to communication of offer. Here the court was in this case, the exposure of goods by shopkeeper was held as to not amounting to an offer to sell. So basically, the shopkeeper had certain goods on uh, on the podium, and it was decided by the court that it does not amount to an offer to sell. Just because shopkeeper has set out some products on the podium doesn't mean that he is offering to sell. However, when the customer will pick the goods, it is an offer by the customer to buy those goods. Okay, and the sale will not be effected until the customer pays the price and the shopkeeper accepts it. Okay, so whenever we see that there whenever we go to a shop, we it doesn't mean that shopkeeper is offering us to buy the products. Okay, we go to the shop, we see the products, then we pick a product and we ask the price of it. Okay, and then we offer to buy that product. Then shopkeeper will tell a certain price, that will be the consideration. We will pay the consideration and then only we will enter into a contract. Okay, so this was the case of pharmaceutical society of Great Britain versus Wood Cash Chemicals. Then we have case of Lalman Shukla versus Gauri Datta. So in this case is relating to general offer. So in this case, it is also a very important, interesting case actually. So here, the person sent his servant to search his missing boy. The boy was missing, and his father sent the servant to find the boy. Afterwards, after the servant left to search the boy, the father declared that he will pay certain amount to anyone who will find the boy. Okay, the servant returned back with the boy, and afterwards he claimed that he wants the prize money because he found the boy. But the court held that the servant did not had this offer, because the general offer was made after he left. He did not listen to the conditions of offer. He did not know the terms of the offer. However, to enter into an agreement, you should know the knowledge, you should have the knowledge of the terms of the offer. And since the servant was not having this knowledge of the terms of the offer, he will not be eligible to claim the prize money. Okay, this was the case of Lalman Shukla versus Gauri Datta. Then we have case of Feldhaus versus Bindle. It is related to communication of acceptance. We have case of Kedar Carlil versus Carbolic Smoke Ball. I have missed that case. No, it is on the top. So it is
Ma'am, have
related
you,
to, yes.
ma'am, have you created a document on these case laws, or we have to like? I'm noting it down though, but have you created any document? Will you be sharing any kind of material with us with regard to the case
I
law?
have not created yet, but I would share it. But it, if you can also find it in your Bear app, but I will share it. Okay, afterwards I will share it.
Sure, ma'am. Thank you.
Okay, then this Mohini Baby versus Dharmadas Ghosh's case is there, and that case is very important case of contract act. It is related to minor's contract, where a minor entered into a contract, and his rights and liabilities were discussed, and it was held that a minor could not enter into a contract. Okay, and if he has entered into the contract and he has enjoyed the resultant of it, then he will not be asked to pay back it. Okay, then let's discuss some questions. I have also highlighted the answers, so it is not necessary to discuss, but okay, let's discuss. The law of contract essentially determines the circumstances in which a contract is a tort and crime. Law of contract is a civil law, it is not related to crime, so first option is not right. A promise may not be made, a promise may be made, a promise shall be legally binding on the promiser. So what law of contract lays down? It lays down as to how a promise could be enforced by the hands of law. So option D is correct. A promise shall be legally binding on the promiser is determined by the law of contract. Offer of proposal is defined in the Indian Contract Act. It is very easy. So direct question is there. An advertisement of auction is, it is not a proposal, it is not a statement, it is not a standing offer, but it is an invitation of offer, where you call all the people, the general public, to offer to buy the certain property which is being auctioned. So invitation of an offer is an advertisement of auction. In which of the following cases is relating to general offer? Lalman Shukla versus Gauri Datta is also related to general offer, and Kali versus Carbolic Smoke Ball is also required related to this. Yes, Vrinda?
Ma'am, could you share your screen?
It's not visible.
No, your screen is not sharing.
Sorry, sorry. I suppose I was sharing. Cannot share. I don't know why, but my screen could not be shared. Just a minute. Now is it visible?
Yes, thank you.
Okay, okay. Sorry. Thank you for reminding. Okay, so in which of the following cases, which case related to general offer? So as I told you right now, Lalman Shukla versus Gauri Datta was also relating to general offer. There was a general offer to everyone who could find the boy, and he will be eligible to claim the prize money. And then there was this Carlyle versus Carbolic Smoke Ball Company, which was also relating to general offer. So both and A and B is the right answer. In Carlyle's case, the facts are there was this company, Carbolic Smoke Balls Company. The company made a drug which they claim that that it will cure influenza, and then they made this offer to the public that whoever will consume their drug, and if within 100 days they contract with influenza, they will be able to claim our prize money, because they, according to them, that drug was so powerful that after consuming it, no one would be suffering from influenza. So to test that, they offered that if anyone could, after following these certain conditions, even after that, after consuming our drug, if you contract influenza, then we will be paying you 100 whatever it is, 100 money. So there was this person, Carlin, who consumed their as per the specific description which was mentioned into the offer. He consumed the drug for the certain period of time which was mentioned in the offer, and even after that he contracted influenza, and afterwards he uh, he claimed the money. So the Carbolic company said that in the court of law, that he claimed the money, but he had not conveyed his acceptance to the offer to us, and therefore the contract has not been entered into. However, the court said that in the case of general offers, when when the offer comes into the knowledge of the person, and the person follows the specific directions which has been mentioned into the offer, it means that acceptance has been done, and it need not be conveyed in case of general offers. Okay, coming on to the next question. An agreement not enforceable by law is stated to be void under section 2G. It is also a very express question which you could directly fetch from your bare act. Which of the statement as to consideration is not correct? It may be past also, it need not be adequate, it must be real, stranger to it cannot sue. So as I told you, contract could be passed, it need to be adequate, need not to be adequate. Yes, consideration could not be adequate. It may be a minimum sum, it may be a sum which is prevalent in market, or it may be higher than that. Okay, and it should be real, it should not be imaginary. But strangers to it cannot sue is not right. Why? Because privity of contract is not applicable under the law in India. Okay, privity of contract is a doctrine which is from common law, and according to that, no third person who is not a party to the contract could enforce the contract. However, in India, under the Indian Contract Act, anyone who is not a party to the contract but who is a beneficiary can enforce the contract, and therefore stranger to a contract could sue. So it is not a correct statement.
Ma'am, but somebody who is a beneficiary is she or he going to be considered as a stranger because he is the beneficiary in the first place? So how can we
Oh,
call that person stranger, ma'am?
see, there may be a contract between you and me. Okay, and the or say suppose there is a contract between me and Legal Vidya to deliver certain amount of lectures. Okay, and you all are the beneficiaries. Okay, but suppose I after entering into the contract and after taking these 4 classes, The next classes, I will not be taking the next classes, and I convey this message to them. Okay, so then you, the participants, since you are the beneficiaries of the contract, you can also get it enforced. Are you getting my point? You are not the party to the contract, but since you are beneficiary,
Okay,
so
ma'am.
there is a difference between the beneficiary and the parties to the contract. See, Mori Bibi
Okay.
versus Dharmodas case is related to minus contract. Consideration is again repeated. It should not be only past, it should not be only present, it should not be only future. It may be past, present, and future. Then there is this question. Initially, A has executed an agreement in the age of his minority, and then after attaining majority, ratified the agreement. Such an agreement is legal or lawful, neither legal nor lawful, voidable, none of the above. Now, as per the provisions of the Contract Act, Section 10, anyone who is entering into the contract has to be has to be major, right? So a minor could not enter into the contract. It is a contract entered by minor will not be called as contract, valid contract. Why? Because the essentials of the contract has not been followed. So a contract by a minor is void ab initio. Okay, it is not a contract itself. So since it is not existing, anything which is not existing initially cannot be existing in future, right? So if a minor who has agreed to certain thing cannot execute that agreement after attaining majority, because it he cannot ratify the agreement when that agreement was not even existent, right? So the right answer will be neither legal nor lawful. So this is all from my side today. Next we will be dealing with the transfer of property and a specific relief act, and if we get the time we will deal with law of torts. If you have any questions relating to today's session, you may post it in your WhatsApp group, and I will try to answer in the next class, or I will send my answers in the group itself. Okay? Ayushi, you may end the session. This is all from my side. If there is anything you have to say, you can.
Thank you so much, ma'am, for such a wonderful session. And thank you, everyone, for joining.